Barnes may sign next case.
S14A0931, Trop Inc., DBA Pink Pony et al. Versus City of Brookhaven et al. Alan Begner for appellant, Scott Burkhold for appellee.
Ms. Bader, you may proceed when ready.
May it please the court, I'm Alan Begner, joined by co-counsel Corey Begner, Aubrey Valines, and Linda Dunleavy. The trial court order in regard to Pink Pony's challenge to Brookhaven's sexually oriented business ordinance and other ordinances on a paramount test challenge the following. And this is in page 1301 of the record. To the claim that the ordinances do not satisfy all three prongs of the paramount test, the court said the trial court finds that the case law and secondary effects reports attached to the answer constitute everything to evaluate this claim, that is the paramount test claim. Therefore, judgment on the pleadings is warranted. This is also discussed on page 13 of the appellant's brief. The court also found in the same voice that all other 14 counts of plaintiff's complaint should be dismissed based upon the case law and secondary effects reports attached to the answer. And so, by considering the material attached to the answer as true and making findings of fact that it was true, the trial court conducted a summary judgment analysis without telling us that they were going to, without notice that such an analysis was occurring, or allowing Pink Pony to respond or rebut the attached evidence, without requiring Brookhaven to submit theories of recovery or facts they say were not in dispute, without allowing us to challenge those, and without oral argument. Of course, the trial court could not call it summary judgment. So instead,
can I just ask, if the case went to trial and Brookhaven put on as evidence of why the city council acted, that they relied on case law and secondary effects analysis, you could put on evidence that that was inaccurate, but isn't the issue whether they relied on it? Not whether it is entirely accurate?
well, that's one of the issues that came out of world-famous Dudley's versus College Park. But there is evidence, there are 3 studies that found there is no correlation. By the dismissal of the lawsuit, the court didn't even look at it. There's a Fulton County police study that we submitted at enactment from 1997, in which Fulton County police found almost half as much crime at adult clubs than at regular clubs. Brookhaven itself did a study, the Macomber report, in January of 2013, showing that there was no correlation in the area of Brookhaven before they incorporated between nude dancing, alcohol, and crime. And the Dan Lenz report, Dr. Dan Lenz, was submitted all at enactment and not sent up as an exhibit to the trial court and not considered. If we're thrown out of court now, none of that gets looked at. So the trial court, since it could not call it a summary judgment, instead rewrote the Civil Practice Act to create a procedure in dramatic fashion, and that rewriting is this, and you can find it on page 24 of the appellee's brief, which I cite. Built upon the notion, it's built upon the notion, and here's the quotes, once the Supreme Court has determined that a nudity ban is reasonable, it would be pointless to require governments to relitigate the issue in individual cases. This is what the court did. It found that all 15 counts had been disproved by the exhibits because other courts interpreting other ordinances that were said to be similar under the U.S. Constitution proved that the issues had already been adversely decided against Pink Pony, even though the studies are only relevant to the Paramount test challenges, not the 14 other counts. And it thereby created an irrebuttable presumption prohibiting the filing of this lawsuit, again, because it had already been decided by other cases, although the court does not say why the other cases, which seem disparate in the extreme, some of them more than 20 years old, unauthenticated copies of affidavits and the like. This is on page 20 of our brief, why that made them similar. It allowed this rewriting of the Civil Practice Act to throw out a case to, in essence, pack the record with untested evidence without allowing us to contest it. The Paramount test allows for us to contest these things. The burden of proof is on the government, not on us to prove them, and certainly we have the right to contest them. And as I say, there are 3 exhibits that were added enactment that the court did not consider. If this ruling is allowed to stand, the use of a 12C motion to find a case on the merits and dismiss a lawsuit, finding in essence it should never have been filed at all because the issues, all of them, had been decided already by other courts, among other things, would have extraordinary consequences. It, for one thing, it is a finding that the Georgia Constitution has been preempted by the U.S. Constitution because they're all U.S. Constitution cases that are cited.
But we've held that the Paramount Pictures test, which is originated in federal case law, is a test for the Georgia and the U.S. Constitution.
Yes, U.S. versus O'Brien is the federal version.
Right, but we've held that this is the same test under the Georgia Constitution.
Well,
It's
I
not
would-
that it's preempted, it's that it's the same.
No, the point is that the U.S. Constitution, the cases submitted as exhibits are cases all decided under the U.S. Constitution as First Amendment challenges under the First Amendment of the U.S. Constitution without the Georgia Constitution's rights to greater powers being considered. That's why it's preempted.
There is a theoretical right, but we have held it in this particular context that it's the same thing, that we're going to interpret the Georgia Constitution identically to the First Amendment, so that a federal case, assuming we agree with it, would have the same effect as a Georgia case.
The federal cases, first of all, all cases have different facts. They have different ordinances. They have different challenges. It is for a court to rely as a matter of fact, that is to find as a matter of fact, that other ordinances bind the trial court is a rewriting of the Civil Practice Act. And it is not true that the Georgia courts defer to the federal courts in First Amendment analysis. In a case called Willis versus City of Atlanta, a 2009 case, for example, I argued this court, and I'll have the cite in a second. The cite is 285 Georgia 775. The City of Atlanta had passed a law banning new dancers in Atlanta from dancing until they're 21 years old. This court unanimously struck the law under the Georgia Constitution when the U.S. District Court for the Middle District of Georgia in Teasers versus Warner Robins and the 11th Circuit had upheld the law under a challenge under the U.S. Constitution. The ordinances were identical. So I do not agree that, and Georgia cases also, there have been 15 Georgia cases since 1989 that have come up before this court on challenges to bans on nude dancing, most of them with alcohol, but not all of them. In those 15, at least 7 times this court upheld the constitutional challenges. under the Georgia Constitution generally, and did so on paramount test challenges, prior restraint, free speech, and overbreath. All of those cases were summary judgment or trial cases except one of the 15. The one that was a motion to dismiss granted for failure to state a claim was Quetgels versus City of Columbus, 264 Georgia 708, a 1994 case, which I sometimes call Quetgels 1 because there are two of them. This court unanimously struck the trial court's decision to grant the motion to dismiss. And I must say, this ordinance, the Brookhaven Code of Ordinances, are not like any ordinance that has been ruled upon by any other federal court, certainly not on a Georgia constitutional challenge. The City of Brookhaven adopted by reference the DeKalb County Code of Ordinances when it began operation, and then amended some provisions. Some of the amendments were made after this complaint was filed. And when Brookhaven adopted the DeKalb County Code, Pink Pony had been lawfully licensed and lawfully zoned for 22 years. One of the things we allege is that we're grandfathered under zoning to new dancing. As a matter of fact, in April, the Brookhaven Board of Zoning Appeals made a ruling in a Pink Pony petition finding, or at least recognizing, that they were a grandfathered new dancing club under the Brookhaven zoning code. And that was not appealed.
For zoning purposes,
Yes.
right? Isn't
Yes.
the case law clear that your licensing rights are not controlled by your zoning rights?
Well, we think we're zoned for both. This is just a partial ruling by Brookhaven. But
Zoning never gives you a right to perform a business. It just allows you to perform it on that particular slice of land.
well, at a minimum, we are grandfathered and under zoning to have new dancing, which is banned there, without alcohol at a minimum.
I don't
Under
understand. I
zoning.
mean, if a place is zoned, for example, for business, or even for a liquor store, are you saying that the city cannot then decide whether or not to license you as a liquor store?
Well, there is some case law that says that the granting of a business license does not automatically zone you for that use. But it all depends on whether you have vested rights other places. One of the things in this case, I hadn't really wanted to get into the merits so much, is a long contract with DeKalb County that goes through 2022, which grandfathers us to a new dancing and alcohol club done way before Brookhaven was more than the glint in the eye of the legislature. And we have argued that a government contract like this is protected under Article 1, Section 1, Paragraph 10 of the Georgia Constitution, which prohibits the curtailment of rights of contract. We've been operating, at least in part, under that contract all through 2013 and into 2014. It's just one of the issues. And Gold Rush, which is a case I also argued, which is used by the city to suggest that there's no grandfather vested rights to alcohol, says unless it is vested by other things or for other reasons. We don't contest the notion that we aren't grandfathered under alcohol either. Still, one other thing, and then I'll reserve time. We believe that on page 7 of the appellee's brief, Brookhaven's counsel suggests that we're in this court because the 11th Circuit has upheld, as he puts it, similar ordinances in the past 6 years, and therefore we chose the state system. My response to that is again, the Georgia Constitution provides more rights to its citizens, including heightened scrutiny, which the U.S. system does not provide. In my many years of bringing and arguing First Amendment challenges in this court, I have almost always picked the Georgia Constitution. I didn't pick the U.S. Constitution to challenge because it does not give the rights to Georgia citizens that the state constitution does.
And let me just ask before you, and in every single one of those cases, this court has applied the identical test under the Georgia Constitution as would apply under the U.S. First Amendment, right?
I don't agree with that. The Paramount test, all of the stuff that has been introduced by Brookhaven in the exhibits is just a Paramount test challenge. We have state zoning challenges, overbreadth challenges that have not been ruled on before, vagueness challenges.
Okay,
Thank you.
Reitzel?
Mr. Chief Justices, Scott Berkthal on behalf. Mr. Chief Justice and Justices of the Supreme Court, may it please the Court, Scott Berkthal on behalf of the City of Brookhaven. Not once in the complaint, in opposition to the motion for judgment on the pleadings, in their first amended complaint, at the hearing on the motion for judgment on the pleadings, in their 35-page proposed order, in their opening brief on appeal, or in this opening argument, did plaintiffs point to any factual allegation in their complaint that the trial court refused to accept as true that would preclude judgment as a matter of law in support of the City of Brookhaven? Justice Nami has hit the nail on the head in that this court has consistently applied coterminous protection for free speech as that provided by the First Amendment to the U.S. Constitution. So much so that when this court decided the Paramount Pictures test, they cited O'Brien and they relied only on the legislative findings contained within the text of the codified statute in Georgia regulating the blind bidding process or prohibiting blind bidding in the motion picture industry. They never had any extrinsic evidence. The Quagles case that Mr. Begner just referenced, it's true. There was a motion to dismiss case in 1994 in Quagles versus City of Columbus that came to this court, and this court said, well, in support of the motion to dismiss, the city didn't adduce any evidence that it relied on these studies. They don't have to be reliable, they don't have to be accurate, but there has to be something in the record that shows that they affirmatively relied on it. Well, that's here in spades. Not only do you have the text of the ordinance and the legislative findings, which lists all the judicial decisions and studies upon which the city relied, which are attached to the plaintiff's pleadings. But in addition to that, you have the legislative record, which is A, incorporated by reference into the text of the ordinance, B, is separately certified by affidavit by the city clerk, and 3, was attached, or C, attached to the city's answer, and under OCGA 9-11-10C, it is part of the pleadings for all purposes. In the Quagles case that he cited, the second case that he mentioned in 1997 that came before this court was a different result. And there the Supreme Court upheld the constitutionality of the statute under the Paramount Pictures test and said, quote, attached to the ordinance at adoption were certain documents referred to in the preamble as evidence of negative secondary effects associated with adult entertainment establishments. And then it cites the Phoenix study, the Austin study, and Indianapolis study. All of those same documents, plus much, much more, are incorporated into the Brookhaven ordinance. So plaintiff's ultimate position is that because there are different facts and different ordinances, that there's no law in this area. In other words, under the theory proposed by plaintiffs, it doesn't matter how many times this court upholds the same separation of alcohol and nude dancing on the same type of legislative record, no predictive value flows from that precedent because no city can rely on it. They have to relitigate it in every case. And therefore, the Missouri Supreme Court in the Ocello case, cited at pages 23 and 24 of our brief, as well as the Sixth Circuit in Sensations and in Deja Vu, and in numerous federal courts that we cited, have upheld judgment on the pleadings for these same types of regulations. Contrary to appellant's representation, the trial court did not go outside the pleadings and convert this into a motion for summary judgment. And the reason is the trial court didn't have to, because the documents that were relied upon were part of the summary judgment, or were part of the pleadings attached to their complaint and their amendment to complaint, as well as the city's answer. Nor did they accept these studies as necessarily true, because under Parker versus Whitfield County from this court, as well as the world-famous Dudley's case from this court, the trial court didn't have to. In Parker, this court said, The county is not required to present evidence that, quote, "the studies upon which the board relied were reasonable or accurate," end quote, only that they met the threshold legal standard of relying on some evidence reasonably believed to be relevant. In the world-famous Dudley's case, this court affirmed judgment as a matter of law, notwithstanding an expert opinion that the legislative record was, quote, "too flawed to establish," end quote, the secondary effects correlation. All that the city had to rely upon was evidence reasonably believed to be relevant. The hearsay argument is new on appeal, but nevertheless, the Club Southern Burlesque case versus City of Carrollton from this court establishes that the city's evidence in this regard is not hearsay because it's not offered to prove the truth of the matter asserted. Rather, the evidence derives its value solely from the credit of the city's representation that it relied upon the studies and considered them relevant. Under that, there's a threshold legal standard that has been met. And the plaintiffs present nothing by way of allegation or evidence at the pleading stage to distinguish them case from the overwhelming on-point precedent from this court. And simply suggesting that there was contrary policy evidence that, by the way, was never mentioned in the complaint, that the trial court was not asked to consider any of the opportunities given, that would not have changed the result. Those are waived. Those arguments are waived. They weren't presented below. But even if they were presented, it doesn't change the outcome because the 1997 calls for service study has been thoroughly repudiated as unreliable, and it's only contrary policy evidence put before the legislative body. And if we know anything from the distilling of this court's cases, as well as the federal cases on point, is that this doesn't allow, the courts are not to sit as a super legislature because the local city councils are in the best position to judge problems and the relationship and the answers to them. As well as the other things that he mentioned, the Lynn study, I think we cited a dozen cases, including Ocello, including Sensations, which considered that evidence and said still not sufficient to overcome judgment on the pleadings. And the grandfathering issue is really a red herring. What he said, it's not only outside the record that in April, the Board of Zoning Appeals allowed the Pink Pony to expand their operations by some 2,700 square feet. It only proves our point, and that is that the city is allowing the use to continue. They can have that opportunity to present adult entertainment subject to the licensing regulations, which are not preempted or covered by zoning. In fact, every one of this court's cases on point dealing with the vested rights issue, including Gold Rush II versus City of Marietta, the Quagles case from 1997, and the Walleye case following that from the Court of Appeals, all involve somebody that was doing something beforehand that was subject to a later licensing regulation and claimed that their zoning non-conforming use protected them against that licensing regulation. And in every one of those cases, this court held that that was not the case. At bottom, the city of Brookhaven carefully followed each of this court's precedents to adopt an ordinance that was constitutional under this court and relevant precedents from the federal courts. We are here today because DeKalb County had allowed an adult use to escape regulation by paying $100,000 a year, and they did so for many, many years. And when the new city of Brookhaven was incorporated, it did not take that deal, and therefore we are here. But the only facts that were alleged were that they operated for many years with new dancing and alcohol, that they paid DeKalb County $100,000 a year under that agreement, and that therefore they had a vested right. That claim, as well as the others, the trial court thoroughly evaluated and rejected them under the governing law, and for those reasons, we ask that this court would affirm the judgment below. Thank you.
Thank you. Any rebuttal?
Thank you. First and foremost, the elements of a 12C motion are well known and very limited. The allegations of the complaint, when construed in a light most favorable to the plaintiff, with all doubts resolved in plaintiff's favor, disclose with certainty that the plaintiff would not be entitled to relief under any state of provable facts. They have to assume the complaint is correct, the trial judge does, and cannot simply find that the facts are disproved by other facts put in as exhibits. And by the way, we had no chance to contest any of the things Brookhaven's counsel has suggested were before the trial court and were considered by the trial court. There was no way to try to even argue that certain studies from Michigan or otherwise are not relevant to our case, and we have an official study from the city saying there is no correlation. And in a case called Flanagan's versus Fulton County, Flanagan's 1, the 11th Circuit said you don't have to do your own study, but you can't ignore your own study if you do one. But a couple other things I had. It has been said by counsel that a waiver occurred for those things which are in our brief, which were not argued below in opposition to the motion to dismiss, but were argued in our brief, citing Pfeiffer. Pfeiffer, 2 years later, which is a summary judgment case, was distinguished by this court in the case of Barnes versus Turner, 278 Georgia, 788, and it found that unlike summary judgment, in which there's a statutory duty to provide theories to the trial judge, it's not true in motions to dismiss. Footnote 6 says the dissent's reliance on Pfeiffer, and it gives the cite, is inapposite. In Pfeiffer, we held that a party could not seek to reverse a grant of summary judgment by raising a new argument for the first time on appeal. However, this case involved the grant of a motion to dismiss. In reviewing the grant of a motion to dismiss, it is the duty of the appellate court to construe the pleadings in a light most favorable to the appellant, with all doubts resolved in appellant's favor. One of the things, for instance, that he has no answer for, that is Brookhaven's counsel, is why this is not premature. 12C says specifically it is premature to bring such a motion until the pleadings are closed. And because it is in the nature of discovery has to occur before such a motion is brought, the pleadings have to be closed. And we have not waived any of our arguments that are in our appellant's brief under Barnes versus Turner. I simply want to add, just in passing, that again, what has occurred here, besides the reliance on documents we saw for the first time when they were attached to an answer and a motion to dismiss was filed.
Mr. Wagner, did you attach those same documents to your pleadings?
I think we amended our pleadings to put the ordinances in,
And
certified copy of the ordinance. We didn't attach the studies.
Didn't the ordinance as certified include the legislative record?
Well, part of it, perhaps. I don't think so. I don't know, Justice Namias.
Okay.
But we certainly did not intend to state about whatever we attached that they could be considered. So the effect of this court's ruling, if there is one, that allows a complete dismissal of all 14 counts of a complaint that's not only obviously well-pled, thorough, and but the trial court found specifically that we had not failed to plead any of the elements in the case, that under the only definition of 12C, which requires the court to consider the complaint as true, the only way it says it could rule against us and did was because the exhibits disproved as a matter of fact and law the well-pled facts in the complaint. Thank you.
On behalf of the court, let me thank both sides for your help. You have directed us or helped direct us in the direction we need to go to reach the right decision in the case. Thank you very much. We'll stand at ease till this afternoon, 2 p.m.